Again, coming to section 81H, there are two very interesting cases that can be brought to your attention as examples about how the application of law on exempted information or information that are not supposed to be disclosed can actually be viewed from. The first is a very interesting case filed by a former finance minister, late Shri Arun Jaitley. He filed a RTI petition to the Central Board of Investigation, CBI, in 2006. And please note, at that point of time, CBI was not an exempted organization under the RTI under Section 24. And a very interesting application that he made to the CBI, because CBI was in charge of the Bofors scandal, investigating the same, unfortunately, which has not come to any rightful conclusion. However, in 2006, there was a news that came about that the government of India, through CBI, had decided to defreeze the accounts of Mr. Ottavio Quattrocchi. And in this case, though there was an Interpol notice issued in 1997 to Mr. Quattrocchi and Mrs. Quattrocchi. However, in 2006, because the investigation was not leading to any conclusion, the government of India decided to defreeze the accounts, and the newspapers reported that the very next day morning, Mr. Quattrocchi withdrew huge sums of money from his London bank account. Now, Arun Jaitley, who was a prominent politician and a lawyer, wanted to get documents about the files that were sent from the government of India to the government of UK, so that such defreezing of bank accounts can actually take place. So the applicant sought all documents, manuscripts and files pertaining to the defreezing of the bank account of Mr. Quattrocchi and Mrs. Quattrocchi. Now, interestingly, the CBI in this case, and successfully though, denied the said information, saying that the investigation is still ongoing, and providing the said information may impede the process of investigation and was a matter that was subjudiced before the courts of law. And interestingly, I think the CIC upheld the contentions of the CBI and denied the said information to Mr. Arun Jaitley. Right? So that is again a very interesting case in which one views the non-disclosure norm that is applicable under the Right to Information Act. Now, we may all think and believe that the said information should have been provided. It's a very important information, and probably the said information is required in public interest. However, at this point of time, it may not be disclosed. So I think public interest is not something that can be judged randomly. It cannot be judged just because of the curiosity that the media and the people have. I think what is necessary is to balance different competing claims as they are. Now, the competing claim over here is in non-disclosure of the said information as against disclosure of the same that was necessary for the media or the public to know. So the CIC denied the said information to Mr. Arun Jaitley under section 81H. When I compare the Arun Jaitley case to a current scenario, there was an interesting application that was filed to the CBI by this gentleman called Vihar Durve. He filed this application and he asked for 6 points in his application to the CBI. And do we know what did he ask? He asked about the total legal expenditure and consultation fee that India has undertaken, both in India as well as abroad, for the extradition of Mr. Vijay Mallya. So he wanted to know how much money has been spent on legal fee on Mr. Mallya, because the extradition process is still ongoing. It's a long term process. The government of India has hired counsels in the UK to get Mr. Mallya back, and obviously there is public money and public expenditure involved, and hence he just wanted to know the total expenditure. So he asked 6 points, but all were in relation to the same, and he asked CBI to disclose it because CBI is the agency that was involved in this process. However, the Central Information Commissioner in this case he had to evaluate. This was Divya Prakash Sinha. He had to evaluate whether the CBI is liable to provide the said information or not. Now, in this case, Mr. Malla's case, as we all know, is a case of probably defrauding public banks and financial institutions in India, and he is so-called liable to be held accountable for a fraud committed on the banking institutions in India. And it is alleged that Mr. Vijay Mallya, through his corrupt practices, has duped Indian banks to the tune of nearly 9,000 crore rupees. And hence, it's a matter of corruption, and being a matter of corruption, the said information should have been provided by the CBI, is what was argued in this case. However, I think the CIC very rightly said that the extradition process is still on; it's ongoing, and being an ongoing process, if any information is provided at this point of time, it would impede the process of extradition, and hence, applying Section 8(1)(h), the CIC denied the said information as an interim order. They said this is not a final order; it is only an interim order. We'll wait for the extradition to get complete. Probably after that, if Mr. Vihar Durve wants to get the said information from the CBI, then a re-evaluation of the same can take place, and then probably the information can be provided for. However, they said as an interim measure, the said information should not be given. And yes, so I think the CBI's concern in this case were adequately addressed, and the CBI was not compelled from sharing the said information, and I think it was rightly done so, protecting the interest of non-disclosure, which is very relevant at this point of time, considering that the case of extradition is at a very crucial juncture. And if the information is leaked or provided under the Right to Information Act, it may adversely affect the extradition process, is what the CBI defended successfully before the Central Information Commission.